Hello, and welcome to another presentation by Global Solutions. In this presentation, I'm going to discuss land patents, land grants, and allodial title. Land patents apply in Canada, land grants apply in the United Kingdom, and allodial title applies in the United States. This document primarily refers to allodial title, however, the same application can be applied in the UK under a land grant or in Canada under land patent. If you have any questions regarding this, you can reach out to the email address on the screen. This is just a short introduction into land patents and land grants, and I have a specific book that relates to land patents as they would apply in Ontario and in Canada. This information has been brought to you because the local municipality is and has done illegal activity in the past, and I've basically spent 40 years of my life uncovering the law or the legal authority to which they operate and to the legal authority to which we can operate. Many people are aware now that the municipality in various jurisdictions is in fact going under the Build Back Better or Build Homes Faster initiative put forth by the Ford government. This is not restricted, however, to Ontario, but in fact is a global agenda. If your property is held under a land patent, a land grant, or allodial title, you have superior authority over that property. You will have to assert your authority through the proper channels and then take the appropriate steps to protect the property. Now, in one such case, there is a golf course not too far from where I live, and they want to redevelop it into this basically 15-minute city, and they intend to encroach on people's property rights and push through a Build Back Better or Build It Again type scenario, which actually, in fact, the municipal people are disregarding the rights and that of the local citizens within my local municipality. This is not restricted, however, to my municipality, and in fact is happening all over Ontario. You should know that if you live in Hastings County, that most of the land is under land patent, if not all of it. And this is true for most of Ontario, as I checked the records previously. Land patent validity and authority. Land patents never lose their lawful authority. The same would apply to a land grant or a allodial title. Land patents have lawful authority, not legal authority. Legal authority refers to an administrative jurisdiction and an administrative court. For the record, administrative courts have no authority over the law. This is a misnomer and basically an attempt to hoodwink the unsuspecting person in court. Land patents are forever documents and create true title to the land. Now, I would ask the viewer to think about something. How can the court have the authority to overrule a contract or an agreement to which it was not part of? The true answer to that question is they don't. Lower court rulings against land patents are doing so from administrative capacity and therefore have no lawful authority to do so. This is going to come to a shock to many people. But the courts, if they're not operating under the law, and in fact are operating under a legal premise, are operating in administrative capacity and do not have the jurisdiction to do so. As I stated on the previous slide, most of the land in Ontario is under land patent or land grant. Legal jurisdiction aspects. Treaty law is constitutionally secured rights and is evidenced by certain U.S. codes. In the United States, it would be Title 18, United States Code, 2071, 241, 242, and 245. Further, Title 43, Section 57, and 83 state that certified copies of land patents must be accepted by all courts in the United States. Now in Canada, if you got a true certified copy of the land patent and can prove a chain of title, then you can use that to defend your property against the municipality trying to take it over, or in fact even tax it. In fact, under Section 17 of the Ontario Municipal Act, the municipality is not allowed to tax your property. The Superior Court is the only Article 3 court in the United States, along with the Federal Court of Trade, and they're the only ones that would have jurisdiction over an allodial title. The lower federal courts are Article 1 or Article 4 courts, not Article 3, and therefore the lower courts have no jurisdiction to overrule an allodial title. Superiority of land patents. Land patents are superior to color of title deeds, i.e. sheriff's deeds, or the local, in Canada, at least in Ontario, it would be the Service Ontario documents, which are now held privately. No lesser court can rule on the force and effect of a land patent. That means your Ontario Superior Court in Ontario would have no authority to tell you that that land patent doesn't exist or it has no legal authority. People should not be sanctioned for updating or perfecting a land patent. Now, in order to perfect a land patent, or an allodial deed or a land grant, you have to get what is called chain of title documents. These can be very difficult to obtain, and many times will involve a trip to the local archives office, and they ask them to give you certified copies of the allodial title. This goes back, basically, it's a chain of title document, which is who was the first owner, who was the second owner, who was the third owner, and so on and so forth, until it comes up to you being the owner. You can also put in a claim under the fact that you have an equitable claim. The municipality or local district or county does not have any sort of allodial title. It doesn't have anything. What you have at the Land Titles Office or the County Recorder's Office in the United States is a record. But a record does not prove that they have any sort of equitable claim. And if you remember from my previous webinars, that when you have an equitable claim, equity trumps all. Now, there are ways to protect your property, which is subject for a different webinar at a later date, and I can go through that if there's interest. Constitutional treaty implications. The Supreme Court cannot rule against a treaty, as treaties are between nations. Now, given the fact that Canada is technically part, or was technically part, of the British Commonwealth, the Superior Court has no right to overrule something which was granted from a higher authority. Public servants and attorneys who attempt to invalidate land patents may be violating their oaths, and in fact they are violating their oaths, because they're going against the Crown, which is the corporation that actually issued the land patent in the first place. Land patents are protected by treaty law and is considered a constitutional document. And we all know that the Constitution forms the creation of the current corporation called a country and the current government. So how can somebody that works for the government overrule the government and its creation through the Crown? It's a simple impossibility. And this, therefore, should protect your land rights, whether you live in Canada, which is part of the British Commonwealth, whether you live in the United States, which was part of the British Commonwealth and still is to some extent, and your land rights in the UK, which is the actual Crown Corporation. Chain of title and updating patents. The chain of title connection to the current owner back to the original patent is crucial for updating a land patent. So again, you'd have to go to the archives and retrieve these land patent documents. There are no restrictions on when a land patent can be updated. Time of date, season, etc. You don't need special permission, nothing like that. You simply get the chain of title documents and file it with the Land Registry Office or the County Recorder's Office or the Land Title Deeds Office, depending on where you are. Once you do that, and they can't refuse you because you do have an equitable claim to the property and you have shown the chain of title documents. You can also advertise this in the local newspaper, and if nobody objects to it, then you can use that and file that along with your chain of title documents and your equitable claim. Chances are that you've been paying taxes to a property which should never have been taxed. You may in fact be paying a mortgage to property which never should have been mortgaged. Understanding your fundamental rights when it comes to land patents and land grants is crucial to taking the next step, and we can take certain measures to protect your property from unlawful and illegal actions by local authorities or other legal engagements that you may be involved in. State statutes and land patents. Statutes have statutes that require them to honor and record a land patent. Remember, the land patent is superior to the statute, and the statute must therefore recognize it. These statutes exist in every state and in every province, and in fact in every country, though they may be difficult to find online. God-given right to land ownership. The right to own land is considered a God-given right, not a government-given right. The government, as I said, has no equitable claim to your property. Land patents are seen as a lawful instrument of a God-given right. I hope you've enjoyed this short presentation regarding land patents, land grants, and allodial title. If you have any questions regarding this, you can reach out to me at the email address on the screen, and I have a specific book that has been written for people in Ontario who wish to assert their legal, lawful, and God-given rights under land patents, land grants. This book is specifically written for people in Ontario. However, many of the arguments and points presented within that document can be used elsewhere. If you're interested in this book, please contact me at the address shown and just simply write land patent book, and I will correspond with you and we can set up the purchase of the book. Additionally, if you're interested in a presentation on land patents or land grants, I can be reached at the same email address, and just put land patent, land grant event, and I will try and coordinate something. It seems to be difficult to coordinate a large-scale event, and so it may in fact be a webinar. And a webinar is anybody can attend from anywhere, and you can do it from the comfort of your own home, and it also eliminates the travel and registration costs which are incurred when anyone runs a public event. I personally would rather have a public event, because then you can ask questions directly and everybody benefits from the question and the answer. With that said, I hope you found this information useful, and I look forward to bringing you additional information as the demand requires and as time permits. Thank you again, and I look forward to hearing from you and presenting additional information in the future.